past few classes, we were discussing about Drugs and Cosmetic Act and its applications in regulating pharmaceutical practices in India. This drug regulates the import of drugs and based on the class in which it belongs to. So that we were discussing at the last in the last previous discussions. Um, Import of drugs, in which we need to know which are the classes of drugs are prevented from importing into India, and which are the drugs need special licenses. Accordingly, C1 is identified, and Schedule X drugs are identified for special provisions for getting licenses for importing into India. Also, we have special permissions for drugs which are imported with the reasons stating that it is for use of test and analysis, and it is required for personal use, and it is of a category of a new drug. It is now first time approved in abroad. So such category of drugs, how it should be imported into India, that we are going to discuss now. So in classes of drugs prohibited to import that we were discussing in the last class, once again we will go through that. The standards, if the drugs are not appropriate in standards, they are misbranded, spurious, adulterated, as it is defined by this act. If these drugs are like that, then once they reach our Indian port, the samples will be collected and be tested by government analysts. The results are not satisfactory. It is found that misbranded or spurious or adulterated, and it will not be allowed to import into India. It will be sent back. Any misbranded or spurious cosmetics also same rule applicable. Any drugs or cosmetics which require import license, and if import license is not obtained and imported, such drugs. So importing license is necessary, but it is not obtained, then it is not allowed to import into India. Any patent or proprietary medicines, for that true formula is not known, it is not revealed, such formulations will not be allowed in India for importing. Any cosmetics containing any such ingredients which may render it unsafe or harmful for use. So if it is found like that, it will not be allowed in India. The drug which claim to cure or prevent any disease or ailment which is listed under uncurable diseases, Schedule J, then that drug never be allowed for importing in India. Any drug or cosmetic, the import of which is prohibited by rule, also will not be allowed. Okay. Apart from this discussion, import of biological drugs, C1 category drugs, what are the necessary things the licensee should satisfy? C1 drugs are biological products which are parenteral type. These biological products include serum, toxins, antitoxins, everything. The license of the import of such drugs, we need to have a license. We have to apply for the license, which is the form prescribed under Schedule A of that same Drugs and Cosmetic Act. The licensee must have adequate facility for storage. Storage is very much important for this product. If the storage condition fails, the product stability as stated by the label will not be maintained during its lifetime. So storage conditions will be inspected and verified every time by the drug inspectors. The licensee must maintain the record of sale, whom it is sold, how many units sold, how many units balance. The licensee must allow the inspector to inspect and collect samples and to verify the quality of the drugs which are under their custody. The licensee, on request, shall supply the samples of drugs from all batches to the licensing authority for test or analysis. If not collected directly by the inspectors, they have to send the samples to get certified. And licensee must not sell the drug from any batch from which sample have been supplied to the licensing authority. Once the samples were sent, reports were not received from the licensing authority, we should not open it for sale. We should wait for the certification from the government authority. The licensee must comply with the undertaking given in Pharm 9. If anything they fails to adopt from that undertaking, then it leads to cancellation of the licenses, and based on the severity of the mistake done, punishments will be there. Import of Schedule X drugs, we know very well, Schedule X are narcotics and psychotropic drugs. So we need additional license for that. So the person who is having license for C1 drug will not have permission to sell, import Schedule X drugs. So they have to apply additionally. The licensee of the for the import of Schedule X drug is granted subject to the following conditions. The licensee must have adequate facility for the storage of the imported drug because it will be misused. Openly, we should not store in lock and key cupboard with their responsibility to be stored. Licensing authority may also refuse to grant the license if the license granted to the applicant previously was suspended or cancelled due to any reasons, any violations. Previously suspended and now they are applying again, the same group, we will not give license at any cost. But the licensee have rights to apply to the government by explain their previous conditions in which the violations were made, and they can sign an undertaking, they can get license. There are options. Drugs imported for examination, test or analysis is another category for which we are permitting to import. So that drugs will not be used for any medicinal or treatment purposes. As it is stated, it should be used only for experimental purpose. License is necessary under Form 2, Form 11 it is. Must use imported drugs only for set purpose and at the place specified in the license. So for whom it is like imported, and only at that site only this experimentation should be done. So the documents should be maintained there. Must keep the record with respect to quantity, name of the manufacturer and date of import. Must allow an inspector to inspect the premises and to check the records of usage made of the imported drug. Import of drugs for personal use. Sometimes some people may need some medicines for the personal use. That medicines may not be available in India, only in abroad. In such cases, special permissions can be obtained to import that drug only for a particular individual's requirement. Small quantities of drugs, the import of which is otherwise prohibited may be imported for personal use without any license, subject to the following conditions. Actually, the drug is not allowed to import in India, but due to emergency need of a particular person, the physician should prescribe that. Accordingly, it will be directed by Indian government to import such drug. The drug shall form the passenger's bonafide luggage and shall exclusively be for personal use of the passenger. Like that only it will be permitted to bring from abroad. It will be in their personal luggage, bonafide luggage only. The drug shall be declared to the customs authority if they direct so. So they have to show all the necessary documents to them. The quantity of such single drug so imported should not exceed 100 doses. So that is the maximum limit. The licensing authority may, in an exceptional case, sanction the import of a large quantity. Drug is not forming a part of bona fide personal luggage if. So they may not allow importing if the drug is more than the permitted quantity and it is not in their personal luggage. The drug is for bona fide personal use. The quantity to be imported is reasonable and is covered by prescription of a registered medical practitioner. By satisfying all these conditions only, the personal use drugs will be allowed if suppose even though it is not restricted to use in India as per Drugs and Cosmetic Act. Import of drugs without license. If anyone involves in import of drugs without license, what is the condition? Substances not used for medicinal purposes. Drugs in Schedule C1 required for manufacturing and not for medicinal use. Substances which are both drugs and food, such as condensed powdered milk, malt, lactose, parrot cereal oats, pre-digested foods, ginger, pepper, cumin, cinnamon containing foods. These foods will not be allowed for importing actually. These drugs are, these materials are not allowed for importing. But in special permissions, they can be used but not for medicinal purposes, stating that they are not for medicinal purposes. So if it is used for other purposes as it is stated, it will be allowed for importing. Penalties related to import. Import of spurious or adulterated drug or drugs which involves a risk to human beings or animals or drug not having therapeutic value. If anyone involves in this kind of importing, that is an offense as per the act. For that, 3 years rigorous imprisonment and 5,000 rupees fine on conviction. And then 5 years imprisonment, 1,000 rupees fine or both subsequent convictions. First time, if anybody does such offense, first category A punishment will be there. Repeated punishments, then it will be 5 years imprisonment and fine. So spurious drugs, adulterated drugs, and the drugs which are risk to the human life or to the animals. If anyone involves in importing, that is an serious offense as per this act. Contravention of the provisions. For every license, we have a provision, set of provisions. Under that, only on the based of conditions only, these licenses will be issued. If anyone finds violating that provisions, then punishment is 6 months imprisonment and 500 rupees fine or both on first conviction. And subsequent conviction, 1 year imprisonment or rupees 1,000 fine will be given. This is the punishment stated under Drugs and Cosmetic Act. Cosmetics prohibited to import. Misbranded cosmetics, spurious cosmetics, harmful ingredient containing cosmetics, not under the standards prescribed, and which contain more than 2 ppm of arsenic or 20 ppm lead, 100 ppm heavy metals containing cosmetics will be harmful to human beings, so that will not be allowed in India for importing. So it is about importing. And manufacturing. This act also controls manufacturing of pharmaceuticals in India and cosmetics also in India. And what way it is going to control the manufacturing processes, means based on the classification of the drug. Why we are classified the drugs into various schedules? Because it facilitates the officials to monitor their usages. So if all brought under one umbrella, so one rules and regulation may uniformly applicable for that category drugs. Like that only Schedule C, C1 are separately deemed. Schedule X are separately deemed. Manufacturing of medicines are done in various ways. Some people, those who have licenses, they will manufacture themselves. Some people, they will get licenses and they will give manufacturing duty to other people. That is called loan licenses. The people will take loan license and they will do manufacturing process for the original brand owner. Repacking licenses, they will do only packing processes. They will collect wholesale pack and they will make retail packs. Make retail packs, that is repacking licenses. Offenses and penalties also listed under this section. See in detail. Prohibition of manufacture drugs not of standard quality or misbranded drugs, adulterated drugs, spurious drugs are not allowed to manufacture in India. It is a very serious offense in India. Patent or proprietary medicines. For patent or proprietary medicines, are only to be done once the formula is known, revealed, and the original owner of the patented medicine, if he obtain license for manufacturing, only then it will be allowed. Drugs in Schedule J. That means Schedule J is list of diseases. Any drugs which are specified to cure such drugs diseases will not be allowed to manufacture in India. Risk to human being or animals. Such materials will never be allowed to manufacture. Drugs without therapeutic value will not be allowed for manufacture. Preparation containing cyclamates. Cyclamates are prevented substances. Such medicines will not be allowed for manufacturing. Manufacturing of drugs other than in Schedule C, C1. Suppose premises schedule other than Schedule C1, C1 means Schedule C, C1 licenses need is only for it is applicable only for biological materials, biological drugs. Other than biological drugs, what is the licensing provisions given under this act? Means the premises should comply with Schedule M. Schedule M is about good manufacturing practices, GMP. So, what are the infrastructures, minimum requirements, how the premises, manufacturing premises should be, how the personnel should be, how the equipment should be certified, all are mentioned under good manufacturing practices. So, they have to adapt these practices. Adequate facility for testing, separate from manufacturing unit that should function in that same campus. So testing unit, quality control section should be separately there. It is independent to the manufacturing activities. So they have to monitor the process. Adequate storage facility is required for after finished goods that should be stored. Records maintained for at least 2 years from the date of product expiry. The manufacturing related records from where the raw material is purchased, how it is stored, how it is procured to the manufacturing unit, who involved in manufacturing, how it is labeled, what are the batch numbers and the sample labels pasted on the product, and how they packed and sent, where and all it is distributed. All records should be maintained. To provide sample to authority. We have to keep our samples to assess the shelf life. Also, we have to send the sample to the monitor, that is certifying authorities uh, to prove the quality of the drug. So, government analyst, we have to send a sample of the each batch. Furnish data of stability. That means we will keep some samples from each batch for shelf life study. So we take samples every month and analyze the content, whether it is having the same content as it is mentioned, the expiry date in the product, or any deterioration occur. That all we monitor. That is called safety related data. That should be maintained. Maintain the inspection book. Whenever the government official is visiting our premises and verifying our manufacturing activities, that should be documented with a proper inspection book. Maintain reference sample for each batch. That's what I said. Sample shelf life testing sample should be kept for each batch. Even it is sent out from the manufacturing area for marketing also. We have to keep some samples for our study. Manual of drugs, those in schedule, manufacturing of drugs, those in schedule C, C1 biologicals. So the previous conditions were given for drugs other than C, C1 category. If they are C, C1 category, we need special provisions for their manufacturing, maintaining the sterility of the product, maintaining the sterile nature during storage conditions, all are necessary. So accordingly, special steps will be taken, and that will be inspected by officials. So, drugs under C, C1 category must be the manufacturing license will be issued in previously sterilized, sealed glass or suitable container. So their storage facility, their procurement details, sterilization records, all will be inspected. Containers should comply with Schedule F. Schedule F specifies what is the pack size of the product, how it should be stored. So that condition should be specified here, satisfied here. And some classes tested for aerobics, anaerobic microorganisms. For example, sera, insulin-containing preparations, pituitary hormones. For that, the special standards were made for presence of identifying the presence of aerobic and anaerobic microorganisms in that. Serum tested for abnormal toxicity. That studies are mandatory, and parenterals in dose of 10 ml or more should be tested for free from pyrogens. So pyrogen free. It should be pyrogen free. Why this less than 10 ml is not tested means the volume is very small, so it gets diluted. So the effect will be, the results of pyrogen effect will be very less, very minimal. So for large volume parenteral, it is must and should tested. Separate lab for culture and manipulation of spore-bearing pathogens, that should be studied, and necessary documents should be maintained about the study done. Test for sterility should be carried out as per the pharmacopoeial procedures. So these are special requirements for C1 category drugs. Like that, we know very well, Schedule X drugs also needs special provisions for that. What exactly we focus means, we focus on the storage facilities, lock and key cupboards, and documents to whom it is supplied, how many quantities are remain with us, how many were supplied to the market, related information. These things only we focus mainly on Schedule X drugs, because their usage should be controlled throughout India, because there are many chances for misuse of some drugs comes under the class of Schedule X. Accounts of all transactions regarding manufacturing should be maintained in serially. That should be preserved for 5 years. If anybody violates, the punishments will be very severe in this class. How to send invoice of sale to licensing authority every 3 months once. You have to send, these are the products manufactured in our premises. This is the condition. Store drugs in direct custody of responsible person. One senior pharmacist will be there with their responsibility. In their presence, it should be stored, and it should be sealed every day. Preparation must be labeled with XRX. This symbol will be there, that indicates they are belongs to narcotic and psychotropic substances class, and also need proper prescription. Marketed in packings not exceeding 100 unit dose if it is a tablet or a capsule. If it is a oral liquid, not more than 300 ml packing, and if it is an injection, not more than 5 ml. This is the pack size that actually made to avoid misuses and overuses of this product only. And loan licenses. Manufacturing is done in loan licenses. We have to know, as per the Act, what is loan license. The Act defines loan license like this: a person who does not have his or own arrangements or factory for manufacture, but who wish to manufacturing facilities owned by another licensee, such licenses are called loan licenses. Like that, the definition is given here. See, you are the owner of the brand. You don't have facility to manufacture, but you are responsible for the entire manufacturing processes. Then you can give loan license to another person, third party, to manufacture and give on behalf of you. So on the label, it will be mentioned that the licensed by, marketed by, manufactured by the owner of the licensed owner of the product. Their names will be there in the brand. So brand will be yours, manufactured by somebody else. So here, actually, before including this provision under the Act, the person who manufactured under loan license will not be questioned. Only the original owner was questioned. Now, both are equally responsible for the quality of the product manufactured. Loan licenses are issued for drugs other than specified in C, C1 and X. Only these, except these classes only, those drugs can be manufactured in loan license. Drugs specified in C1 class also can be manufactured with a separate license, with a special license. So repacking license. So what exactly the Act says about repacking? We'll see. Process of breaking up any drug from a bulk container into small packages and labeling with a view to their sale and distribution is called repacking. See, the original manufacturer will send 1 lakh tablets in one container, like that big containers they'll send. Some industries will do only packing processes. So for that also they need licenses as per the Drugs and Cosmetic Act. What they are going to do, they are getting that wholesale packs. They'll open the container and they will pack it into 10 tablets in each strip, like that. They'll pack it into strips, blister packs, or small bottles as per the requirement of the local market or the requirement of any particular hospitals. They'll pack and they will send it with another label. They'll paste over the container another label. So for the label pasted over that, the repacking license owner is responsible. The repacked containers is the responsibility of the repacking owner licensee. So it is not the responsibility of the wholesale manufacturer. Wholesale manufacturer will have manufacturing license separately. Here, this another group of people, those who are packing into small containers, they will get another type of license, and they are only responsible for the repackings. Repackings of the drugs is granted of drugs other than Schedule C, C1 and X only, because see, we have large volume containers that cannot be opened and repacked. That will affect the sterility of the product, so that never be allowed. C, C1 category drugs and Schedule X, there is lot of chance for misuses. If the original packing is opened, something adulterated in the container, and chances of misuse is there, then the original manufacturer also will be in problem, because they taken responsibility after in presence of them. The materials were packed and sealed. So if anything opened by any third party, then they will be in a problem. So this is not allowed. So other than drugs under C, C1 category and X are allowed for repacking. Penalties related to manufacture. There are severe punishments for manufacturing of any spurious drugs. 1 to 3 years imprisonment and 5,000 fine. 2 to 6 years imprisonment and 10,000 fine. And next subsequent convictions. Manufacturing of adulterated drugs, 1 year imprisonment to 2,000 fine, and 2 years imprisonment to 2,000 rupees fine for subsequent convictions. Manufacturing of drugs in contravention of the provisions, any violations of the manufacturing licenses, for that imprisonment up to 3 months and 500 rupees fine. Subsequent convictions, imprisonment up to 6 months and 1,000 rupees fine on subsequent. These are mentioned in this Drugs and Cosmetic Act. So cosmetics also same rules applicable for manufacturing. And next section is sale of drugs. For that also license will be issued. So we close our discussion now, and we continue in our next class. Thank you.